Confidentiality and client rights. Elizabeth Simpson.
So in this next section, we're going to be focusing on confidentiality and client rights. And this covers sections A, B, and E within the CRCC Code of Ethics.
Reads from slides.
So laws, 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 so many laws that we might have to consider as CRCs and working with adolescents and pre-ets. Of course, the CRCC Code of Ethics and the other codes of ethics you may have to abide by when applicable come into play. Agency policies are a big one. So your agency may have policies that are different from other state agencies in terms of what services are provided and how they're provided more specifically within pre-ed services within the schools. School policies are going to differ by county, by district, however a school system might be broken up. So it's really important to make sure that you're understanding of what those school policies are, so you can know what your role is within the entire process of working with students with disabilities, as well as what supports they may have within the school, and policies and practices, best practices that a school might adhere to if there are issues. And there are, of course, state and federal laws that could apply as well in terms of confidentiality and keeping client rights at the forefront. And again, these are all unique to each state and can be changing all the time depending on case law. So it's important to kind of keep abreast of new things coming down the pipeline with state and federal laws.
Involvement of others.
So there, understandably, if you're working in pre-ed services, you're working with an interdisciplinary team member. And you're working specifically with an IEP team in pre-ed services. So there are a lot of others that you're going to be working with that also have to abide by a set of ethical codes typically. And so confidentiality is something that's throughout every ethical code that I've ever seen. So it's important to take into consideration how those ethical codes may differ, how your responsibility to the counselor or as the counselor to the client may be a little bit different than another member of your interdisciplinary team, and how their code of ethics discusses confidentiality as it applies to adolescents and working in schools. Does the CRC Code of Ethics apply to those without the CRC? It does not, but that doesn't mean that somebody that does not hold a CRC has a set of standards that they must abide by. And remember, in terms of confidentiality, you're always going to be going back and looking at the school policies that are in place, the federal laws, state laws, because those oftentimes apply to a broader category of helping professionals that would encompass anybody on that IEP team or the interdisciplinary team. Other service providers certainly may come into play when you're working with pre-eds, and there may be a need to share certain information with those other service providers. So it's important to remember that those codes of ethics and the CRC Code of Ethics really outlines how to share information about an adolescent or minor with a disability, and what information you can maintain confidentiality with when working with that age group. And can legal options be requested from attorneys? Absolutely. I would teach students all the time that if you're working as a counselor, you hope that you're working with an agency that has somebody on standby or is able to consult with an attorney to find out what they can or cannot do or should not do in terms of breaching confidentiality. And clients have that option as well. So there are specific reasons that the CRCC Code of Ethics outline to break confidentiality, and these apply within pre-eds as well as just general vocational rehab counseling. So if the student or adolescent with a disability is posing a danger to themselves, a danger to others, if they are telling you that they're experiencing past or present child abuse, if there's a court order, or if there is knowledge of a contagious or life-threatening disease. So again, minimal disclosure is key when you are looking at an issue or situation or dilemma where you might need to break confidentiality with a minor. And it's always good to disclose to youth and guardians the limits to confidentiality and exceptions to confidentiality right up front whenever you're first starting services with students in pre-eds. So you could do this in a group setting when you're working uh, with the students and starting your pre-ed services, it's going to look a little bit different than when you would be having that confidentiality talk with a client in your office space. And you want to make sure that depending on the age group that you're working with and the ability to reason and understand the material, that you're presenting confidentiality in a way that the students would understand. It's also good to provide a printed document or a document in alternative format for the parents as well and guardians, as well as the students, so they can have a record on that the discussion was had and that confidentiality was talked about.
Group work.
Group work also poses unique confidentiality issues, if you will. So there's no way to completely guarantee that information shared within a group setting, and this is for any counseling specialty area, but that information shared by clients, students, adolescents, whomever in a group setting is going to be maintained and kept confidential, because we really can't, we can't keep somebody that is another member of that group from sharing information outside the group. If they want to, they're going to do it. We can't sit by each group member every day, all day, to make sure that they're keeping information confidential. So these limits to confidentiality within a group setting should most certainly be addressed right up front and reiterated throughout the process, the group process. And in group work, it can be useful really to, in the first stages of the group, and there's always these general processes and stages in group counseling, and that those do apply to pre-eds group counseling as well, but setting norms and rules for that group. So the students and adolescents with disabilities then have that autonomy to develop these rules and the guidelines that they are going to adhere to as members of the group. And I think when working with adolescents and youth with disabilities, you know, you can certainly emphasize the consequences of sharing information outside of that group for everybody and themselves, and the importance of keeping things private and keeping information that's shared within that group within the group. The CRC Code of Ethics talks about group work in sections A.7 and B.4. Screening for groups might be done by the school. There are certain areas of the code that we might want to take into consideration if we are developing our own group and tools for screening group members. But when we're working in pre-eds, oftentimes the schools might be providing you with a list of students that then you would be contacting to start services via group. And so what are some of the challenges in running a group with minor clients versus adults? Again, an understanding, I think, of confidentiality and the negative consequences of breaching confidentiality. Within the younger age groups, you might have to do a little bit of kind of classroom management, if you will, when working with a group, setting boundaries within that group setting as well, making sure that the groups are very structured, depending on the individuals that you're working with.
Documentation. Things to consider.
So when it comes to documentation, there are certain things to consider that would also tie into our CRCC Code of Ethics and working in pre-eds. We're looking at section B6 here. When it comes to case notes and pre-ed services, you may not be the only one reading case notes. And so it's important to remember that others may be or have privilege to look at that information. Documentation has to be secured, meaning that you don't want to be leaving files in an unlocked car in the school parking lot. But oftentimes now we're just using secure documentation that's electronic, which is fantastic. However, technology might not be as secure as we've been taught. Even with encryption and security, breaches can still happen. And so it's important to, again, address those issues with guardians of students and adolescents with disabilities early on at the very onset of the provision of services, so that they're aware that you can do the best that you're able to do. But ultimately, if a hacker on the other side of the planet wants to get into the case notes, it may be a possibility. Other privacy laws come into play, specifically FERPA and HIPAA within the school systems Information within the school systems can be accessed by parents. So you just, again, want to be mindful about the documentation that you're keeping on the students that you're working with in pre-eds.
Documentation don'ts.
So some documentation don'ts, things to be mindful of when you are completing documentation. Over documentation is largely unnecessary. Make sure that information is relevant and necessary to include whenever you're documenting case notes. Under documentation, this could include failing to document telephone calls, significant events or decisions that were made along the way, disclosures of informed consent. It is very important to document whenever that has occurred, so that if you ever need to go back and say, yes, I did discuss disclosure and I did get informed consent from a client and their guardian, and here's when I did it. That's very important. And failure to obtain and review prior records. So if you're coming in and taking over a caseload for another counselor, for example, it is really imperative that you go in and read somebody else's case notes, so that you can be well aware of where you're coming in with a client, and ready to start services again. Kind of that nice continuity in services for the client. And again, that's a good example of when somebody else might be reading your case notes. You may not be staying in this position that you're currently in forever, but your clients may be on a caseload for a while. And so it's important to make sure that you're not just writing documentation for yourself, but you're writing it for the others that may have that privilege to look at the documentation. Missing documentation would be a documentation don't. Any releases of information, anything in writing or via electronic signature. You want to have all of these things in place prior to releasing any information, and keeping these releases in the client's record. Ineligible handwriting. If you have trouble reading it, so will others. That's kind of a standard. Again, I think now that we're using technology and we're documenting things on our computers, that is less of an issue. But nevertheless, if you are still using paper forms, intake forms, whatever it might be, especially if you're doing some of the group work and pre-ets, you want to make sure that your handwriting is legible.
Documentation.
Not everybody is aware that there are a couple of different easy ways to write case notes. One is the SOAP note and the other is the DAP note. The SOAP note simply stands for subjective, providing subjective information, the client's interpretation of his or her presentation or their main complaint. O being objective, the counselor's objective observations about the client's presentation. A being assessment, the counselor's assessment of the client's condition and progress at time of visit. And P stands for plan, the counselor's plan for treatment and the visit and things that will happen after that visit. Now, P is very, very important, making sure that you know what you're doing next and how you're going to be reaching a goal. And then the DAP note stands for D. D is data involving objective information, what happened in the counseling session, A, assessment again, and P, a plan. So the DAP note is pretty simple, I think. D kind of, the D in the DAP note really just is made up of the subjective and objective information in the SOAP note. And I'm going to turn it over to Linda now to talk about confidentiality in the law.
Linda Batiste.
Thanks, Elizabeth. This is a really interesting topic to me. In addition to what Elizabeth's been talking about with your ethical duties to keep client information confidential, you also have a duty to keep information confidential under the Americans with Disabilities Act. You really play two roles as a VR counselor. You're a service provider providing counseling services. You're also considered an employment agency for ADA purposes. And the distinction there is very, very important. As a service provider, your duty to keep medical information confidential is very similar to your ethical duty, meaning that you have to have a valid reason to share medical information. So you don't want to make any unnecessary disclosures. In your role as an employment agency, however, you have to follow the requirements under Title I of the ADA that employers have to follow. And this is a more stringent requirement. Generally, you have to keep all disability-related information confidential. And there are various stages of employment where those rules can vary a little bit. At the pre-employment stage, basically, you're not allowed to share any disability-related information with employers. That's the rule that employers have when working with other employers, and that's the rule you have when working with employers. And what this basically means is, you may go to an employer and share that you're a VR counselor and that you'd like to place some of your clients there, and that's fine. You're absolutely entitled to do that. But when it comes to placing an individual client with an employer, you don't want to go in and talk about accommodations needed on the job or what kind of medical condition your client has. Basically, you're not allowed to share that type of information, even though in your mind you think that might be helpful for the employer to have and to understand. Employers may feel the same way. They may be asking you, well, what disability does your client have? What accommodations may the client have? And you need to maybe plan ahead of time how you're going to respond to employers' direct questions about your client's disabilities. There's various ways that you can respond to that. One is directly to say, under the Americans with Disabilities Act, I'm not allowed to share that information with you. Another way that may be a little more comfortable is to say that that information is going to be shared with you post-job offer if relevant, and my client will be the one sharing that information with you as needed. Putting that responsibility on your client is probably the best approach. You may end up having to help the client with that information. And on the next slide, I want to talk about some of the things that clients may need to understand related to disclosing a disability. Elizabeth, if you can move that to the next slide. So because generally disclosure is up to the client, and it's their choice when to disclose and how to disclose, you may not be directly involved in the disclosure to an employer, but in my experience, especially with youth, they don't really understand disclosure rules and ADA rules and the best way to make a disclosure. So some of the issues you may need to discuss with your clients is, when is the best time to disclose? And again, it may be a personal choice, but I think individuals need to understand the pros and cons of disclosing pre-job offer, during an interview or on an application. And if they decide to disclose, they need to know how to do that. How much information to share? Do you do it in writing? Do you just have a conversation with the employer? Again, what are the pros and cons of the different approaches? And then who to disclose to. Sometimes individuals just want to be open with their disability. They want to share it just like they would any other personal information. And again, that's their choice. But if they just want to disclose it in line with what's required under the ADA, if they're going to ask for an accommodation, you may want to educate them on some pros and cons of different methods of doing that. I've listed a resource here, the 411 on disability disclosure, which is a workbook for youth with disabilities related to disclosing a disability. This has been around a long time, but I still think it is one of the best resources for young people who are entering employment maybe for the first time. On the next slide, I want to share just some things that we have also. We do get lots of questions from individuals about disclosure issues. So we've developed a page on our website devoted to disclosure information, ADA guidelines, as well as practical guidance. You may understand the law, but that doesn't mean that answers all your questions about how to go about disclosing. We also have a training module and some videos about disclosing that you can certainly share with your clients, maybe watch together if you prefer. They just go over the ADA rules and again, provide some practical ideas for handling things in disclosing to employers. So if you haven't taken a look at that, take a look at it. We've got lots and lots of information, and we can also help with that on a case-by-case basis. Back to you, Elizabeth.
AskJan.org/topics/disability-disclosures.cfm